them that unresolved issues from polling stations will be noted on Form 8B for resolution at the constituency collation centers. Is that correct?
That's correct, my lord.
You also train them to expect to receive the duplicates of the Form 8Bs that have been given to them at the polling stations. Is that correct?
That's correct, my lord.
Now, you also train them to cross-check their Form 8Bs with anything that is done at the constituency collation center. Is that correct?
That's correct, my lord.
You also train them that from all the information on Form 8B, the EC officials will collate the results onto Form 9. Is that correct?
That's correct, my lord.
You train them that after collating on Form 9, the results will be entered on Form 10. Is that correct?
That's correct, my lord. But all with the involvement of our agents.
Now, you also train them that if they have any issues with Form 10, they could refuse to sign it and state the reasons therefore. Is that correct?
That's correct.
Now, you also train them that once the Form 10s were completed, they were entitled to their copies.
That's correct, my lord.
So it is right to assume that your agents had all the Form 10s with them. Is that correct?
Come again, my lord.
I'm saying that it is right to assume that based on your answers, your agents had the Form 10s with them.
Yes, my lord, it could be assumed.
Right.
Now, whether that is the case is another matter.
Now, you also agree with me that with our elections, results are declared at all the polling stations before they move on to the constituency. Once the results are counted, they are declared at the polling station before we move on to the constituency centers.
Yes, my lord, unless there is a challenge about a particular polling station results.
Yes. And at the constituency level, the collated results are put together and then a winner of a particular constituency is declared. Is that correct?
We have two elections at the constituency that are collated at the constituency level. I don't know which one. Is that the presidential or parliamentary?
Sir, you are here because of the presidential election. Is that correct?
Okay, yeah.
My question is in reference to the presidential election.
The declaration is not done at the constituency level. They indicate the tally for each candidate. The presidential election results are declared at the national level by the returning officer.
Are you therefore saying that at the constituency level, your agents do not know who has this number of valid votes at the constituency level?
That's what I'm calling the tally. The tally of the votes are known, but that is not the declaration of the presidential election.
Okay, good. You trained your agents that the Form 10s will be transmitted to the regional collation centers. Is that correct?
That's correct, my lord.
Now you also appointed agents to each regional collation center. Is that correct?
That's correct, my lord.
Indeed, some of your agents, as announced publicly, were lawyers. Is that correct?
That's correct, my lord.
Now, you also trained your agents that all the information on Form 10s will be collated onto Form 11. Is that correct?
That's correct, my lord.
You also trained them that from collating the results on Form 11, the results will be entered on Form 12. Is that correct?
That's correct, my lord.
Now, you also trained them that at that point, they would be invited to either sign onto the Form 12 or object. Is that correct?
That's correct, but they are involved, so they are not sitting somewhere only to be invited to sign. They are involved in the collation, and if they agree that the process has been proper, they are invited to sign.
Okay. Now, are you aware that of the 16 regional collation forms, your agent signed 13 of them?
Yes, my lord.
Are you also aware that one of such forms that was signed was in reference to the Ashanti region? Is that correct? One of the forms that your agent signed, it was in reference to the Ashanti region?
Yes, my lord.
Your agent signed the form for Ahafu. Is that correct?
That's correct, my lord.
Your agent signed the form for Oti. Is that correct?
That's correct, my lord.
Your agent signed the form for Northeast. Is that correct?
That's correct, my lord.
Your agent signed the form for Bono. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper West. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper East. Is that correct?
That's correct, my lord.
Your agent signed the form for Central Region. Is that correct?
That's correct, my lord.
Your agent signed the form for Western. Is that correct?
That's correct, my lord.
Your agent signed the form for Savannah. Is that correct?
That's correct, my lord.
Your agent signed the form for Volta. Is that correct?
That's correct, my lord.
And your agent signed the form for Bono East. Is that correct?
Bono
East.
Bono East. Bono.
It was signed by Ali Mohammed Samsudin.
That's correct, my lord.
Good. Now, on each of those forms, your agent signed to declare as follows. Quote, we the undersigned do hereby declare that the results shown above are true and accurate account of the ballots in the region. Is that correct?
That's correct.
Now, at the National Collation Center, which is the headquarters of the first respondent, you appointed 2 persons to that place for the collation. Is that correct?
That's correct, my lord.
One of such persons is Rojo Metonunu. Is that correct?
Yes, my lord.
And Mr. Rojo Metonunu has been a former deputy minister before.
That's correct.
And Mr. Rojo Metonunu has been involved in elections and has even litigated 2 cases in these courts. Is that correct?
My lord, I can't testify to the fact about his litigations, but I know he has been involved in our elections.
Now, there's a reported case. Okay, right, okay. Right. Now, are you aware that at the National Collation Center, Mr. Rojo Metonunu certified 12 of the 13 forms signed by your representatives?
My lord, I cannot testify or deny, but the other agent who will be present in court to testify as to what happened in the National Collation Center, my lord.
Right. Now, let us go to your witness statement. You spoke about Exhibit D, the letter from the National Democratic Congress.
Yes, my lord.
Dated 9 December 2012. I suggest to you that that letter was not delivered to the first respondent.
My lord, our agent who was in the headquarters of the first respondent will be present in court and will attest to that fact.
So you do not know whether it was submitted or not?
A report was made back to me that it was submitted.
I am putting it to you that that letter was not submitted to the first respondent. Yes. I am putting it to you that that letter was not submitted to the first respondent.
My lord, that fact will be confirmed or denied by the agent who will be in the box subsequently.
So you are telling this court that you do not have personal knowledge of whether or not the letter was submitted to the first respondent?
My lord, I indicated that I had a report, a feedback that it had been submitted, and since I wasn't present there, I cannot say it as a matter of something that has come to my knowledge.
Right. Now, let's go to your letter. Your letter is in two parts. Is that correct? You can look at it.
You have it.
It is marked Exhibit D.
Yeah.
Would you be kind enough to tell the court the person who signed this letter?
My lord, it was signed by my deputy on my behalf.
What's the name of the person?
Peter Boama Otokuno.
Right. Now you agree with me that the portion marked C talks about parliamentary elections and therefore has nothing to do with the petition in this court.
Yes, my lord.
You also agree with me that despite all that you've written about Ashanti, Ashanti was signed by a gentleman called Broja Jemfi. Do you know him?
Yes, my lord.
And I'm further putting it to you that Ashanti was signed by, was certified by Mr. Rodo Metonunu.
My lord, the agents who will come subsequently will be able to confirm that or deny it.
Do you know whether Rodo signed or not?
Please, I would like to take the question again.
I'm asking you whether you know that when Ashanti came in, duly signed by Mr. Broja Jemfi, Rodo Metonunu signed against it. Do you know or you don't know?
My lord, the documents that come to our notice is the final declarations, the signing on the regional declarations at the strong room are not brought to us.
Well, I'm putting it to you that for Ashanti, the form was signed by Broja Jemfi in Ashanti region, and
yes,
when it was transmitted,
I can testify.
And when it was transmitted to the strong room, as you call it, Mr. Rojo Metonunu signed it.
Well, I can testify or deny because what happens in the strong room is within the knowledge of people who are in the strong room.
Now, you have attached to your letter 2 sheets from the Eastern region. Is that correct?
That's correct, my lord.
On the first sheet, your agent signed the form. Is that correct?
My lord, there are 2 sheets. I don't know which is first and which is second.
The second one is what you have. There's one that your agent did not sign. If you look at the forms, there's one, the one with the blue ink at the bottom, your agent did not sign.
Yes.
The one that doesn't have the blue ink, your agent signed.
Yes, my lord.
Right. Now, if you put together all the valid votes assigned to each of the candidates that your agent signed, the total will be 1,196,751, and not the 1,236,940 that was written on the form.
My lord, I have realized that the totals there are. Yes, I've looked at. Yes, my lord, that is precisely what I'm about to do. I have done the collations, the additions, and I've realized that the totals on both sheets are the same figures, but the figures that add up to the totals are different. And the one marked in blue is actually accurate.
No, we'll come to the one marked in blue. I am saying that if you add up all the valid votes assigned to all the candidates from number 1 to number 12 on the form that your agent signed, the total should be 1,196,751 and not the 1,236,940 that was written on it.
My lord, I can confirm that the totals are not the aggregates of the numbers there, but I don't remember the actual figure that I got. If the court will permit me, we can add and find out what it is. Yeah. But all our forms have been taken.
My lord, my lord, we brought the calculator.
Yes.
If the court will permit, you can do the addition.
Yes.
Order in court, please. Order.
1, 4, 6. Five, 4, 7, 6. No. 1, 2, 9. Yes, your calculator is not 1, 2, 9.
It's order in court.
My Lord, I have 1,196,751. Correct.
Now, kindly deduct that figure from the figure written on the form. That is 1,236,940. What will you arrive at?
$40,109.
40,000.
109.
189.
189. Sorry.
It is 189.
Yeah.
Good. Now, look at the last page of your Exhibit E, which is the sheet that you attached to your evidence.
Yeah.
Are you listening? Now, there is a constituency there called Ayenswano. Ayenswano. Do you see 40,189 over there?
Yes, my Lord.
I am suggesting to you that the second sheet that your agent did not sign was corrected to include the Ayenswano constituency results.
Well, I cannot testify to that because if there is any correction to be made on any declaration, those who are part of the declaration must be present for the corrections to be made.
Yes, but you also are aware that where the person whom you have appointed to represent you leaves and refuses to be part of the process, those who are there sign onto the form and the process continues. You are aware?
Yes, I'm aware, but
now I am putting it to you that when the Ayenswano results were added, all the candidates got the additional votes that they got in Ayenswano, thus making extra gains to make the total valid votes 1,236,940. I am putting it to you.
My Lord, can you come again?
I am putting it to you that when Ayenswano results, that I have just shown you that if you take the difference that you got from the first sheet from what they had written, you get 4189. And that 4189 on your own spreadsheet Exhibit E, it is spread across all the candidates. The only person who didn't get a gain was Hassan Ayarika. I'm saying that if you put it together, the gains that each candidate made in Ayenswano, the total will now come to 1, 2, 3, 6, 940. And I'm putting that to you.
Yes, my lord.
Good. Now, therefore, I am further putting it to you that the Eastern region sheet had no problem, for which you ought to have written to the first respondent.
I deny that, my lord.
Now, I am further putting it to you that the 3 remaining constituencies that your agents, the 3 remaining regions that your agents did not sign, the petitioner won those regions.
My lord, if the figures are in contention, we are not able to determine who won.
Now, those regions are Western North, Northern, and Greater Accra. I'm putting it to you that the candidate won at those regions when the coalition was done. That's the petitioner.
My lord, I repeat that if the figures are in contention, it is difficult to determine who won.
Now, are you therefore saying that with respect to Greater Accra, you do not know that the petitioner won the election?
My lord, you claim my agents did not sign, which means that it's part of our case that the figures are in contention.
You see, I am putting it to you.
And in the presidential elections, regions are not won.
Yes, my lord. Well, my lord. Well, my lord.
In the presidential elections, regions are not won. There is one presidential elections and one returning officer who declares the winner at the national level. No other declaration of the presidential elections take place anywhere else.
Right. Well, I am putting it to you that for the record, Western North was won by the petitioner, and the Western North form, although not signed by your representative, it was certified by Mr. Rojo Metonunu in the strong room.
My lord, the agents in the strong room will mount the witness box and they will be able to testify whether they signed or did not sign.
Do you still stand by your petition in this court? The petition that you filed, do you still stand by all the averments in it?
Yes, my lord.
Now, let's look at paragraph 12 of your petition. Sorry, the petition of the petitioner, sorry. Paragraph 12 of the petition of the petitioner. Kindly read paragraph 12 to the court. Paragraph 12.
Yeah, I'm ready.
Paragraph 12 of the amended petition, sorry, my lords. Have you seen it?
Yes, my Lord.
Kindly read it to the court.
If the total number of valid votes standing to the names of each of the presidential candidates is summed up, this will yield a total number of valid votes cast of 13,121, 13,121,101, a figure that is completely missing from the purported declaration. 111, a figure that is completely missing from the purported declaration by Mrs. Jean Adukwe Mensah on 9th December 2020, and the purported ratification on 10th December 2020.
Now, I am putting it to you that the figure in the paragraph 12 of the petitioner's petition shows clearly that the number mentioned by the first respondent as the valid votes, total valid votes, was an error, which you have admitted in your petition.
Can I hear the question again, please?
I am putting it to you that as at the time you filed this petition, you knew that the figure 13,121,111 was the correct total valid votes that ought to have been announced on the 9th, as you have said in your petition. I'm putting it to you.
My Lord, these are figures we computed from the first respondent's own data that was supplied. These are not our figures.
Well, you are bound by your petition, so let's go on. At the point that the declaration was going to be done, you have stated that your agents, Mr. Metununu and Dr. Pesa White, left the strong room. Is that correct?
That's correct, my Lord.
I am putting it to you that they left the strong room because they realized that the petitioner had lost the election.
My Lord, I can't attest or deny that one, and these are matters in the personal knowledge of the agents who will be mounting the witness box subsequently.
And they left the strong room because they didn't want to sign the Form 13.
I can't attest to that.
And I'm putting it to you that the total valid votes as at the 9th of December 2020 and captured on Form 13 is just the same as the total valid votes in the form in paragraph 12 of the petition.
My Lord, we don't know which is the total valid votes as we stand here, because the first respondent has turned out several different figures. So our case is that Ghana does not know the results of the presidential elections as we sit here now, because the petitioner who has the constitutional duty to conduct the elections has not, the first respondent who has the constitutional duty to conduct the elections and report an exact figures has failed in that duty. So we are confronted with several figures, and it depends on what you want to believe.
Are you saying that you do not believe in the figure that you wrote in your petition?
My Lord, I stated that we picked these figures from the respondents' own calculations, not ours. We haven't supplied.
And I am putting it to you that if your representatives had not left the strong room, they would have seen that those figures, 13,121,111, was the total valid votes as captured on Form 13.
My Lord, I can't respond on behalf of the agents. I have indicated that one of them will be in the witness box to testify.
I am further putting it to you that 8 out of the 12 presidential candidates stayed back and signed on the Form 13.
My Lord, I have indicated that the processes within that National Coalition Center are not within my personal knowledge, and so I cannot answer, I cannot admit or deny.
Now, at the time the petitioner filed this petition, he knew the results from the Petition South constituency, not so?
My Lord, I'm not the petitioner.
Okay, we'll leave it. We'll address it.
Now, let me refer you to your form, your Exhibit E. Look under Bunu East. Bunu East.
Yeah.
Do you see the valid votes that the petitioner obtained?
As per the computation of the first respondent, yes. Because these are not our figures, they are figures from the first respondent.
Right. You also agree with me that the petitioner never obtained all the 128,000 registered voters' votes from the Techiman South constituency as you purport to show in your evidence. I'm putting it to you.
Well, there's nowhere in the evidence that you purport to say that the petitioner was all. Respectfully, there's nowhere in the evidence where the witness says that the petitioner got all the registered votes in Techiman. There's nowhere in the evidence to that effect. And I think this is just to kind of mislead the witness.
Yes, my lords. My lords, I am not, with the greatest respect, misleading the witness. Lords, as at the date that the witness filed his witness statement on he signed his witness statement on the 27th of January 2021, he, in paragraph 12, sought to make analogies with the Techiman South total number of registered voters. And that is why I am asking him genuine questions based on his own documents that he has brought before the court.
My objection is very simple. He's made a specific statement that the petitioner, the petition says that all votes in Techiman South were won by the petitioner. There's no way. This talk about by analogy and so on. Let him point to where in the witness statement.
Mr. Amenuvo, please.
Yes.
Reframe the question.
Now, yes, my lords.
He's raised an objection. What is your response to that?
You are reframing the question.
Lords, I'll rephrase the question.
Okay.
Right.
And then tell me that.
Now, as at the time you filed this petition, I am suggesting, as at the time you filed your witness statement, I am suggesting to you that you could not include paragraph 12 because the total valid votes that the petitioner had obtained were known. I'm putting it to you. In the Techiman South constituency, they were known.
As at the time
You were
filing the witness statement?
Yes.
Yes.
They were known.
Yes.
Good. I'm further putting it to you, therefore, that as at the time that they filed, the petition filed the petition, all the total valid votes in Techiman South were known.
On behalf of the petitioner.
So I am putting it to you.
Yes.
That using all the total valid votes in the Techiman South constituency, that's registered voters in the Techiman South constituency, to do your analysis is incorrect. I am putting that to you.
My Lord, the analysis was based on what the first respondent herself claimed. So all the information there, all the figures that were stated there were from the first respondent's own account when they were declaring the results. And if I may proceed, the first respondent claimed that even though they have not had the results of the Techiman South, they feel secure to proceed because even if all the votes of the Techiman South were to be added to the petitioner's tally, it will not change the outcome.
Yes.
So the analysis we did there was to show that based on the figures she herself declared, that statement could not be correct.
I am putting it to you that the first respondent's chairperson was right, because as at the time she was making the declaration, you knew that the total valid votes in the elections was 13,121,111. I'm putting it to you.
My Lord, I don't understand the question. That I knew, or the chairperson who was doing the declaration knew. Because I didn't do declarations.
You, as the witness in this box, you knew about that. I'm putting it to you.
That when the first respondent was making the declaration on the 9th, that I knew that the total figures, total of the votes was 13,121,111.
Yes, because you stated so, the petitioner stated so in his petition, that ought to be the correct number, and the first respondent in her answer agreed with you. So I'm putting it to you that you knew.
My Lord, you see,
the question.
I don't understand why you seem to be confusing me with the petitioner. because I don't understand.
You see, that's why we have to strike out some of the evidence, because you can't speak to them. And so that's the basis upon which we have to strike out some of the evidence. And we are confirming our position.
Oh.
Well, I'm still waiting for the answer.
I'm saying that I cannot answer for the petitioner. You're asking me questions that ought to be asked to the petitioner. Right. And I'm saying that I'm not.
So, won't go into that. I'll leave it for you.
I took these figures from the respondent's declaration.
Now,
And before they were declared, I couldn't have known what he was declaring.
The figure at the time.
now, can you read paragraph 13 of your witness statement to this court?
My Lord, paragraph 13 of my witness statement. When the percentages of valid votes cast and standing to the names of each of the presidential candidates. On my witness statement, okay. Witness statement. Have you taken? Yeah, you've taken the witness statement.
It's over there. Let me show you. Bring book.
It's here. Paragraph 13. Yeah, paragraph 13. The Techima and South constituency has a total registered voter population of 128,018. And if added to the total valid votes announced by Mrs. Jane Adukwe Mensah as cast, which is 13,434,574. The resultant figure would now be 13,562,592. Consequently, if all the votes of Techima South constituency were added to petitioner's votes, second respondent's vote will remain the same at 6,730,413, now yielding 49.625%, while the votes of petitioner will increase to 6,342,907, now yielding 46.768%.
So I'm putting it to you that you knew the results from the Techima South, and therefore this analysis of yours is incorrect.
My Lord, I beg your permission to quote paragraph 12 of my statement. That will explain the meaning.
Please
of
answer the question and then you can explain.
Okay.
Answer the question. I'm saying that at the time you were making this statement,
Yeah.
you knew the exact results of the Techima South constituency, and therefore the analysis that you had made was wrongful. Answer the question, yes or no. If you want to explain, you explain.
The analysis was right because it was based on a statement made by the first respondent at a certain point in time. So if you are analyzing that statement at that point, I don't see how you bring in the current situation to be able to answer that statement.
I suggest to you that you are wrong because the current situation is the reality. The court deals with reality, not conjecture. I'm suggesting that to you.
My Lord, the current situation cannot be the reality because nobody knows the results of the presidential elections in 2020. Nobody knows in exactitude how many votes each of the candidates got and what percentage each of the candidates got. And the first petitioner, the first respondent, in her own words, and my Lord, I beg to quote in my own statement, currently, the election results we have declared exclude that of Techimai South constituency, with a voter population of 128,018. The third election results are not ready because they are being contested. Even if we were to add the 128,018 full results to the results of the second candidate, it would not change the outcome of the election. Hence our declaration of the 2020 presidential results without that of Techimai. The respondent was justifying why she had to declare results based on uncompleted tally. And we are questioning that statement, that statement could not have been correct as at the time it was being made.
I am putting it to you that as at the time the first respondent's chairperson made that statement, the statement was correct and it is captured in paragraph 12 of the petitioner's petition.
I decline that.
Very well. Now, what was the source from which you obtained information to draw up your Exhibit E for this honorable court?
My Lord, Exhibit E was based on the first respondent's own data.
But you have gracefully brought it to the attention of the court. You want to rely on it. Is that not so?
Yes, we want to rely on it to the extent that we want to prove a case against the first respondent.
No.
And I'm comfortable, I'm a teacher, my Lord.
Now, my lords, in Exhibit E, there are votes assigned to the petitioner and the second respondent and all the other presidential candidates. Is that not so? That's on the last page of Exhibit
By the first respondent, yes.
Now, what we have here is 677-6066 for the second respondent. Is that correct?
From where, please?
That's the total,
Yeah, the
total valid votes.
yeah.
Is that correct?
6,776,066.
That's what is on it. Is that correct?
I don't know. Yes, it's in this statement.
Yes.
Yes.
And then also for the petitioner, we have 6,265,276. Is that correct?
According to these documents submitted by the first respondent.
No. It is your document we are looking at, please. Now, look below the figures we have just gone through. For the second respondent, there's a percentage of 5.126. It is down there. That's 51.126. Sorry, 51.261. The way they have rendered it, that's why. 51.
0.51.
Yes.
63.
0.51261471. Is that correct?
That's correct.
Now, I am suggesting to you that this works to a percentage of 51.2614.
A percentage of what?
A percentage of the total valid votes also on this sheet.
It's 51.263%.
That is correct.
Yeah.
Right. Now, for the petitioner, we have 47.397 assigned to him by your sheet. Is that correct?
47.397. Yes.
Right. That's correct. Now, deduct the number assigned to the second respondent. No, deduct the number assigned to the petitioner from that assigned to the second respondent and tell this court the difference.
Which of the numbers? You asked about percentage.
6.
You are now asking.
6, 7. Yes, I've moved on from percentage. 6776066 minus 6265276. What do you get?
677.
As it's not that good, I think you'll be stretching the witness.
About 510,790.
Thank you. Thank you very much.
It's okay.
Yes. It is, you got 510,790.
Yes, my lord.
Right. Now, it is not true that the first respondent padded any votes as you allege. I am putting it to you.
My lord, I decline that assertion.
Now, in your Exhibit F, you allege that 4693 votes was added in favor of the second respondent. That is your allegation.
My lord, if you look at my statement, I indicated that I'll bring a sample of the constituencies and polling stations where padding took place. I did not indicate that that is an exhaustive list of all the places where the padding took place.
Sir,
we
are using the numbers that you have brought to the court to assist the court. I am saying that the total of 4693 is what you have put down there. Is that correct?
I brought it as a sample. I did it in my statement, actually indicates that this is from a sample of this particular constituency. I don't understand sample to mean a total of the population.
Now, deduct the 510,790, you deduct the 4, sorry, my lords, deduct the 693 from 510,790. What do you get?
With all due respect, I don't see the point of the
With the greatest respect, you are being rude to the court, not to me.
Okay. Yeah, come again.
I'm saying that deduct 4,693 from 510,790. What do you get?
693. I got 506,097.
Good. I am suggesting to you that even if this, your number, as alleged, which is denied, even if it is deducted from the total valid votes of the second respondent, he still has won by your own sheet by 51.246%. I am putting it to you.
My Lord, I deny that because that you are subtracting apples from mangoes.
1 point.
Well, this is a sample. You want to take a sample from a population of another group. I don't see where the calculation is coming from.
You see, I am suggesting to you that you have no evidence to support your allegation, and that is why you have brought only what you have. I am putting it to you.
My Lord, we are not in court to try to declare another presidential results by us. We are in court to challenge the performance of a constitutional duty of a first respondent and to see whether that duty has been discharged faithfully.
If that is so, then I'm suggesting to you that you are not, by your own showing, you are not in the right forum.
I decline that, my Lord.
Now, you had earlier told this court that you cannot speak to what happened in the strong room when your two representatives were there.
Yeah.
Is that correct?
That's correct.
My lords, on that basis, I'll end my cross-examination of the witness.
Yes, my lord, I do. So, Mr. Seydou Nkatia, you recall that before the declaration of 9th January 2021,
December.
9th December 2021,
Hey, Mr. Kutampa.
oh, relax. 9th December 2020. Your party and your presidential candidate held a series of press conferences on what you consider to be the outcome of the elections. Is that not so?
It is so, my Lord.
And in those press conferences, you announced to the whole world that the petitioner had won the presidential elections and was, by the votes you had collated, the president-elect. Am I correct?
My Lord, that is not in my witness statement.
Sorry? Where is it? Yes, the paper. So can you answer that question? You did say so, didn't you?
Come again.
I said your party, including your good self, and the first petitioner, and also one Otokuno, your deputy, together with other leading members of your party, you held several press. So I'm putting it to you that your party held a number of press conferences.
Yes, my lord, that is so.
Now, in those press conferences, or in some of them, you were present and you spoke on the issue of the results of the presidential elections.
Yes, my lord.
The petitioner himself also spoke on the outcome of the presidential elections.
Yes, my lord.
And your as deputy, Tokuno, equally spoke on the results of the presidential elections.
My lord, I can attest to my statement at a forum where the petitioner was present and he spoke. But I don't remember being present at a forum where my deputy spoke.
Now, you know that your presidential candidate, that is the petitioner, asserted that he had won the 2020 presidential elections.
My lord,
Ghanaians had voted for change.
my lord, what I remember the petitioner said was that the results as declared by the first respondent is not accurate.
Now, I'm also putting it to you that you yourself declared that the petitioner had won the presidential elections.
My lord, unless I'm reminded, but I remember saying that NDC has won parliamentary majority in parliament, and that will give President Mahama a comfortable situation to be able to run the next government.
So I'm suggesting to you that by that statement, you were saying that the petitioner had won the elections and was going to become the president.
My lord, there were all indications that he was going to become the president.
Not indications. I'm saying that by what you said, you meant that he had won the elections because that was the only way he could form the next government.
My lord, if I meant that, I would have said so.
Mr. Asedun Ketia, we served on the petitioner our witness statement.
Yeah.
You are aware?
My lord, I'm not the petitioner.
I didn't say you are the petitioner. I said we served on the petitioner, our witness statement.
Yes, I'm aware he has been served.
Have you seen a copy of the witness statement?
Yes, I've seen it.
Do you admit that in the witness statement of the petitioner, of the second respondent,
Yeah.
we have attached Exhibit 6?
Exhibit
6. 6.
This one. Yeah.
This is hours. We are looking for hours.
This is
Yes, can you answer?
Yes, I've seen this in a brown envelope.
So we presume that you know the contents. So we presume that you are speaking, you know the contents of that video clip.
Well, my Lord, I have not played the contents, so I cannot testify that I know what is contained in there.
My Lord, I would need some direction here. This is a problem that arises at trial in the High Court. Our witness is not at that moment giving testimony. A witness on the other side is giving testimony, and you want to confront him with material or exhibits in your witness statement. In our witness statement, to discredit him. What he's saying. Now, at the time that he would have finished his evidence and stepped out, when we lead that evidence, he will not be available to respond to the content of that evidence. We want to play the video so that we will exactly. Yes, my Lord. Very well. Yes.
Mr. Kutuampa.
Yes, my Lord.
You are conducting your case. So if at a point you think that there is evidence which you want to make an application to the court to allow you to either show to the court, you have to put that application before the court. But as it is, you've not made any application. We have to give the other side the opportunity to respond. What you're asking is you want directions from us.
Yes.
So you know what to do.
My Lord, may I with your leave, make an oral application to have the video that we've attached to our witness statement played out so that we can properly confront the witness with his own acts and that of the petitioner, together with leading members of his party, on the issue whether or not they declared to the Ghanaian public that petitioner had won the election.
You have to address us on relevance. So what is the relevance? What would this video
My Lord,
establish?
the relevance is that the petitioner and his supporters or his leadership led Ghanaians to believe that they have won the election and that there was an attempt by the first respondent, together with, in collusion with the second respondent, were trying the will of the people, and that they had all the necessary pink sheets to demonstrate that they had won the elections. When they came to court finally, after a lot of pressure from the public that if you won't come to court, all they are saying is that if you use the errors in the chairperson of the first respondent's announcement, then neither party has won, so there should be a rerun. It goes to their good faith and credibility in this matter.
Mr. Kutuampa, anybody at all can call a press conference and declare himself or herself to be the winner of an election. And you mean because I called a press conference and declared that I have won an election, that should be taken as the law?
No.
We have laws, we have regulations,
No.
and how we know how to declare our results.
My lords, where a major party in the republic, like the NDC, is mobilizing its...
Mr. Kutuampa, you see, the witness is denying these allegations. Yes, that is why you have your witness statement together with this, would I say, proposed exhibit or whatever, served on him. If it is your time, or if your time comes, then you have to put in.
No,
yes.
My lords, what I'm seeking to, I'm actually applying to the court for leave to play the video and use it because it's part of our case, and use it to cross-examine the witness. And my lord, I'm saying that this is a difficulty.
You are talking about credibility. You want to establish credibility.
Yes.
Yes, so you haven't said so.
No, my lord, I said it goes to his credibility. I said so.
You have to premise your application in the rules, and you have to premise your application in the rules of court and in the Evidence Act. That's your job. That's your burden.
My lords, I mean, our application is relevant to this petition to the extent that it demonstrates the credibility of the petitioner in respect, the credibility or lack thereof of the petitioner in respect of the 2020 presidential elections. And yes.
So what is your submission? What is your submission? What is the application that you want us to?
My application is for leave for the video.
Confront him with the exhibit.
Yes.
Okay.
Because he's been very evasive, almost to the point of denial.
The challenge we have is that you did not give any indication prior to this hearing that you want a video to be played.
My lords, it's attached to our witness statement that I believe all your lordships have copies of. And I have every reason to presume that you know that we'd like to play it.
I'm not sure whether the registry, Mr. Registrar, I'm not sure whether there is any provision made for that. Do you have? Yeah.
I will take an adjournment.
My lords, I respectfully, I believe that we have not been heard. There have been several steps of questions and so on. We have not been heard even in respect of his basic attempt. Okay.
Submission, the application. He said he was making an oral application.
Right.
Yes.
Yes, that's why I was saying that my understanding was that the question from His Lordship Justice Amagache was about the practicality of implementing that.
Yeah, it has not been granted. So we have to hear you before we can rule on it.
Very well.
Yeah, okay.
My Lord, in the first instance, it is the case of the petitioner that is being made by this witness. And therefore, evidence that he says is part of their case, that evidence has not yet come in. And your lordship will see that, in fact, literally, whilst in the box, he opened that envelope. I mean, it was clipped. I think we all saw that. It was clipped, and he answered that, I mean, he has not seen that tape. So, my lords, in terms of the answers that he's given when the matters have been put to him, he has answered those matters. Now, the question now it is now being proposed that even before they bring in their witness statement with this flash drive, it should be put to him. That witness statement is not yet in evidence. It's not been adopted in evidence. So my Lord, with respect, the procedures are simply being confused.
From this witness statement, which is, would I say, an invention into our rules. Well, you see, in some years back, before the coming into force of the, is it CI 37? 87. CI 87. Yes, you can just ask a witness under cross-examination that, please look at this exhibit. Did you append your signature to it or whatever? That was the practice. But yes, then you may even tender it through the witness under cross-examination, which was permissible. But of late, because of the CI 87, it is.
You remember, if you are conducting cross-examination, if you remember, you can pull out a document.
Yes.
And show it to the
the witness. Yes.
Yeah.
Lord,
that document may not be in evidence.
My Lord, I have absolutely no problem.
So it's the same principle.
No, my Lord, with the greatest respect, what he was showing the witness was an attachment to a witness statement
yeah.
that has not yet been adopted. That's very different from the...
So it is not evidence yet. It's not evidence yet.
No, my lord, with the greatest respect, I'm saying that your lordship has described a scenario which is clear in terms of the procedure other than the procedure that is being used now. In that procedure, that evidence would not be part of a witness statement or anything like that.
Yeah.
It would be a document that in itself can be tendered through the witness. And I don't have a problem with that. I'm just saying, my lord, and I think with the greatest respect, this is also an indication of a problem arising from the fact that the case management process was truncated, with the greatest respect. Because, my lords, in the case management process, you would normally be able to indicate these materials which you would want to put to the witness. Then in the case management process, your lordships would have the opportunity to make this practical arrangement that was being described by his lordship Justice Amagenshi, whereby if that is a document or that is a video that they want to show and so on, that as a piece of evidence to confront him would be catered for. So, my lords, I'm respectfully making two very simple points. Firstly, in terms of the procedure that he's seeking to adopt, bringing in a witness statement and an attachment to the witness statement, that is irregular. Secondly, because that witness statement has not been adopted. So
it's not evidence yet.
Yes.
So that is why they can do what they are doing. Because it's not evidence until they come to the box and adopt it. It is no evidence. So it's like they are having a document. They want to confront the witness with the document. That document is not in evidence yet.
That is why
so we are speaking the same, we are on the same level. We are on the same wavelength. What they have now, even though it has been filed, is not evidence. So they have it.
Yes, but my lords, you heard him. The application that he made is that it is part of our case that so and so.
Yes.
He said that.
Yes, so it's just electronic evidence. If it were any ordinary document, he could just give it to the court clerk to show it to Mr.
Yes, my lord, as you said, we're on the same wavelength in terms of the practice related to showing a document, a video, or whatever. We are absolutely on the same level. I'm just referring to the way in which he sought to bring it in through referring to the witness statement, which is not yet in, to a witness who is under cross-examination as the petitioner's witness. That's all. But, my lord, clearly, documents can be put to the witness under cross-examination. I don't have a difficulty about that. That's why I was saying that the practical problem that we're in right now is because if in case management it had been understood, and I believe that was the question that His Lordship Justice Amagenshi was asking, if it had been understood that that document would be required for the cross-examination, then arrangements would have been made practically for that, because it happens to require some technology for it to be shown. So that is what I'm saying. And so we're in a situation where, the practicalities do not allow for the procedure that your lordship is referring me to, which I agree is a procedure that can happen under cross-examination. But because of the way that it was sort of introduced, we've ended up in this situation. So if we can, I suppose, go back to some case management and so on. And I mean,
all we need to do is to secure the equipment that can be used to play to the video to the witness. That is.
My lords, it was precisely because of this that when I got up, I sought to have directions of the court because of the new novel processes of witness statements and what it means for putting your case to
Mr. Kotamka, even if we were not in an era of case management prior where you bring all you show all your evidence, you still would have access to this through the Evidence Act. It's just about electronic evidence as compared to paper evidence. And so the system has to be set up if you apply fully.
We have actually notified the registry that we would be needing very well. Very well. My lords, but that is why I made the application. Oh.
My lords, once you're considering these practicalities, I would like to indicate that we would, by the same token, especially once the technology is available, we would wish to have the declaration made on which he has testified and which is part of our witness team, the declaration made by the chairperson of the first respondent to be played also. We have the exhibit, so we would also, just for the sake of completeness, because whilst we're discussing all this technology, I think very well. Exactly, that's all I'm saying.
So, by court, counsel for the second respondent wants the court to have access to the content of a prospective exhibit which has been annexed to the witness statement. As this attachment is not in evidence now, we hereby order that it should be placed on the next agenda date for us to ascertain its admissibility on the grounds of relevancy. Yes. Yeah. Yeah. My court, the petition is adjourned to Monday, the 1st of February 2021 at 9:30 a.m. for continuation of cross-examination. Yeah. Please, you've not been discharged. Yes. So Monday, they may continue to conduct the cross-examination.
Very well, man.
Yeah, I will tell you.
We are ready to collaborate with the registry to provide the necessary facilities, if need be. Very well.
Thank you for your unsolicited assistance. Danny?
All rise.
Abuafo, Tabia Jumeko, Yasan Bawabobo no biem. Na afeidie, ye the Tabia hand sanitizer, and na brewo. O my pa, ubetimi abon ho ban. Every mwa, yemfa ye ni enhunu ho. Na eku 99.99%